Also, by the way, I wanted to clarify for the dangerous and unusual standard when it comes to the Heller dicta that they used. Specifically, use stun guns, particularly if you really want to get your rights back, because of the Catella versus Massachusetts case. That already foreclosed the disagreement about that because stun guns are commonly used in self defense. People commonly use those for lawful purposes. That foreclosed the argument that they don't from the opposite side. So you have that right to use stun guns, as is clearly protected under the Second Amendment. So use a stun gun particularly to use your right to exercise what rights you have left, which is that. So just to clarify, use the stun gun in a state that allows you to use a stun gun despite being prohibited federally, and then use that as your basis for your as-applied Second Amendment challenge when you're arguing the presumptively lawful aspect of 18 USC 922 G4 when you apply an as-applied injunctive relief challenge against that law. Just to clarify, just letting you know. There's different arguments that the government could use to try to justify why you don't have that right, but ultimately speaking, the Supreme Court ruling overrules any bullshit argument that the federal government can use against you during your injunction. Because as it stands, the Second Amendment covers stun guns, okay? You demonstrated that you're outside of the typically historically barred people by possessing a stun gun, which is a protected arm under the Second Amendment. Even if the Supreme Court says that felons and the mentally ill don't have Second Amendment rights, because at the end of the day, you are a U.S. citizen that is part of the political community that has other protected interests and other constitutional rights. You have a First Amendment right, you have a Fourth Amendment right, you have a Fifth Amendment right, you have every other constitutional right because you're a part of the people according to the Constitution. That means that the Second Amendment is not any different than any of the other constitutional rights that are guaranteed to you. Period blank, no ifs, ands, and buts about it. That's just how it's supposed to be. Like I said, 18 U.S.C. 922 G4 only bans you from having certain types of ammunition and firearms, which is modern ammunition, 1898 or younger. Period blank. And the dangerous and unusual standard doesn't apply because, yeah, stun guns are dangerous, but they're not unusual because they're commonly used by lawful citizens. Period blank. So your case would absolutely win in federal court if you use this standard alone. Period blank. It doesn't matter if you're not part of the people because at the end of the day, statutorily speaking, you're not barred from using stun guns, and using that as a defense for the Second Amendment is a great defense to win your case. So just letting you guys know that. Again, I know I have to keep clarifying it, but there's going to be a lot of rebuttals against these types of things, but it has not been tested yet. And again, I'll say this one more time. Based off other Supreme Court cases and this and that, the legislator, Congress, can constitutionally prohibit somebody through legislation. But because there's lack of legislation through the use of stun guns or any other dangerous weapon that's not considered a firearm, constitutionally speaking, you still have this right. Like I said, only constitutional right that they took away is the right to bear firearms, modern ammunition, and that's it. So, again, I'm just going to say that, yeah, that's how you can get your rights back if you specifically argue this particular case. So that's just how it's supposed to be. I'm trying to think of anything else. If there's anything else I could use. If I could think of another analogy, then I'll bring it up in another video, but that's what I can think of for right now. So just letting you know. So, yeah.